his colleagues that developed this movie, and I was happy to see also a few film stars are present today. Recognize at least one, was there? So, yeah, if there are any questions, please, regarding the subject or regarding this film, please don't hesitate to address, to ask Eric. So, which leads us actually to the next presentation on opportunities and challenges in the implementation of the Nagoya Protocol. And so, I'll use this one here. Yeah, as I said before, the idea of this second presentation today is actually to look a little bit more into the implementation aspects at the national to local level. And so what I will do is actually run through, let's say, some key elements that national legislation or national ABS measures, to put it better like that, could include. But before that, just let's talk quickly about the starting point. Where are we? I mean, the Nagoya Protocol was adopted in 2010, but it's important also to remember that at the same conference of the parties of the CBD, the Nagoya Protocol was a package, or part of a package. Now the presentation. And this package included the Nagoya Protocol, the CBD strategic plan, and also the resource mobilization plan. And if you look at the CBD strategic plan for 2011 to 2020, we have two so-called Aichi targets that are very relevant with regards to ABS. First of all, Aichi target 16 clarifies that by 2015, or that the parties have agreed that by 2015 the Nagoya Protocol should be enforced and operational consistent with national legislation. So this is the target specifically on operationalization, ratification, operationalization of the Nagoya Protocol. But in addition to that, Aichi target 17 refers to updating national biodiversity strategies and action plans, which is another important issue to keep in mind in this regard. It says that by 2015, such NB subs, that's the acronym, should be developed and adopted, and existing ones should be revised. Now, these NB subs, these national biodiversity strategies and action plans, currently or in the past, focused very often only on two of the three objectives of the CBD, the sustainable use aspect and the conservation aspect, and ABS was less addressed in those strategies. Now, it is, however, clear from the decisions that the parties to the CBD adopted in the past that those national biodiversity strategies and action plans should provide also effective and up-to-date national frameworks for implementation of all three objectives, so also including ABS, which means in this process of adopting new NB subs or revising existing ones, the ABS aspect should be integrated. Furthermore, we need to keep in mind that obligations under an international agreement may be self-executing under certain conditions. That depends practically on whether a party is a monist or a dualist state. A monist state means that the international law or international agreements are directly part of national legislation, while dualist states certain or differentiate between the two and require normally an implementing national instrument. So, but regardless of which doctrine a state might follow, whether it is a monist or a dualist state, it is important to remember that the ratification of the Nagoya Protocol itself, so just so far we have 5 ratifications, that can only be a beginning for the implementation process. And why is this the case? Because if you look and read carefully the Nagoya Protocol, it includes many instruments and many interesting and important obligations. However, many provisions are drafted in a way that they oblige countries to take domestic legislative, policy, or administrative measures as appropriate, which means that the states, the countries, have a lot of flexibility in what kind of measures they're going to take in order to implement the Nagoya Protocol. The Nagoya Protocol very often does not specify concrete measures. And we will see some of these examples later on. So it is basically not concrete enough to be applied directly at the national or local level. It needs further implementing measures. Such measures for implementing ABS, they can be included in regional strategies, policies, legislation, regulations, but also in codes of conduct, at least some of the obligations. But as I said, regardless of the approach, certain key elements need to be addressed, and this will be the focus of this presentation. And again, the choice which measures will be taken by a respective country will depend very much on the national circumstances. Not that it is about whether a country considers itself as a provider or a user country, but it is about whether, for example, a country has indigenous and local communities, whether it has traditional knowledge, also, of course, how the overall legal system looks like. We've seen that in the role play. There's a federal state where the federal states have certain competencies, and there are centralized states. So everything will depend on the national circumstances with regard to the choice of measures. And one important point and one key message that I think we want to highlight in our event today is that we need to understand that every country is, according to the Nagoya Protocol, a potential provider and user state. So every country, whether it considers itself as provider normally because it has rich biodiversity, or whether it considers itself as a classical user because it has a successful bioprospecting sector, needs to implement all or take all measures, so-called provider measures as well as user measures. Now, the first key element that can be addressed in those ABS measures is to clarify the objective that a country wants to pursue with its ABS measures. These objectives can be clarified in the ENVI subs again, but also in other ABS legislative, administrative, or policy measures. What is important is that the ABS regime that is created is in the end mutually supportive with all the other broader set of policies, the legislation, the existing legal frameworks that exist in other areas such as science and technology, natural resource management. We raised this morning the issue of protected areas management, forest management, marine resources. There are already existing frameworks to govern those sectors, and in the end it is important that the ABS regime, which is a cross-cutting issue, needs to be harmonized, and synergies need to be identified. And also issues like ownership of biological and genetic resources. This was one of the points in our fictitious scenario. Rights of indigenous and local communities, industry policies and trade. The issue of intellectual property law is highly relevant. And then also, Andreas mentioned it this morning, the relationship with specialized international agreements, such as the International Treaty for Plant Genetic Resources for Food and Agriculture. All those developments and processes currently being taken in other fora like the World Health Organization or the World Intellectual Property Organization. What could those objectives look like? They could refer to certain, be based on certain principles like valuing, first of all, the utilization of genetic resources and as an ecosystem service, and also of associated traditional knowledge for different purposes, commercial and non-commercial, in order to reflect the socio-economic development aspect, but also, of course, with regard to conservation aspects, sustainable use of biodiversity. An important principle is also the issue issue of facilitating access, which is already an obligation coming from Article 15, paragraph 2 of the CBD. This has been again strengthened, let's say, by the Nagoya Protocol, and so access shall be or could be facilitated, or the objectives of the ABS regime could stress out that access needs to be facilitated in a non-discriminatory and environmentally sound manner, and based on fair and equitable systems of sharing benefits. And last but not least, supporting compliance with ABS regimes of other countries is highly relevant and also needs to be considered when developing ABS regimes. The scope, a properly defined scope, will define the success of ABS measures, such as legislation. It needs to determine the application of the overall regime to particular materials and associated knowledge or information, geographical locations, such as land territories, but also marine areas, activities, certain activities, again, and actors. The problem is if the scope is too broad, then this might lead to implementation problems in the end. And of course, also the scope can define certain resources which are excluded. For example, looking at the Nagoya Protocol, the scope has been clarified to a certain extent. However, there is still, if you look at the language, which refers to Article 15 of the CBD, this leaves some flexibility for national interpretation, but what is clear is that generic resources used as bulk commodities, again the example that Andreas mentioned this morning, wood here on the ceiling and so on and so forth, that is excluded from the Nagoya Protocol. Such resources which were acquired before the entry into force of the CBD, resources accessed in areas beyond national jurisdiction, do not fall under the scope of the Nagoya Protocol. The question is whether the Law of the Seas Convention might address this issue, and there are negotiations or discussions going on. And also, of course, if a country determines not to require prior informed consent in the end. Definitions is the next key element. Such definitions in all implementing measures are necessary to define and clarify certain key terms, and they need to be defined in order to give an agreed specific meaning to certain terms when the meaning is not clear per se, when the specific term should have a different meaning than in the normal usage, or certain key terms such as in the context of the Nagoya Protocol and the utilization of genetic resource and traditional knowledge, the term itself, or also access. What does that mean? That these are key terms that need to be also defined clearly in a national domestic ABS regime. Just to highlight those two, the access term, which is access is not defined neither in the Convention on Biological Diversity nor in the Nagoya Protocol. There are different ways you can, or other terms you could decide to use instead of access, such as prospecting, bioprospecting, or biodiversity prospecting. However, even those terms would need to be clarified because they also give flexibility for interpretation. The definition of the concept of utilization is a basis for functional ABS system. First of all, because the obligations, and we quickly talked about that after an intervention this morning, after a question, the access for purpose of utilization of genetic resources will trigger obligations under the Nagoya Protocol. It will trigger, for example, the obligation to share benefits. Access for the utilization of biological resources, again as commodities, for example, would not trigger obligations under the Nagoya Protocol. Access, not only it needs to be determined or defined, it also needs to be further regulated. That's the next key element of domestic measures. We need to keep in mind, we cannot repeat it often enough that states have sovereign rights over their natural resources and the authority to regulate access. Therefore, an access shall be subject to prior informed consent according to the Nagoya Protocol, which means that prior informed consent is the norm. That's the usual case. However, as states are sovereign in regulating access, they can also decide not to require prior informed consent, which means unless it is otherwise determined. It is important also to know that it is not sufficient to just stay silent. If you look at the classical user countries, to use this term, the many European countries, industrialized countries, their legislation does not regulate whether access is required or not. It's simply silent. And if you read the Nagoya Protocol closely, then you will find out that this is not enough. States need to clarify whether they require prior informed consent or not. They are also, when making a decision, they are also free to decide when prior informed consent is required or not. So to determine access requirements, should prior informed consent apply to all genetic resources only, or only to particular categories of genetic resources, for example, such resources that are found on public lands, or those where co-ownership, like in our case, might exist, and so on and so forth. Also, whether prior informed consent is necessary for all or only some purposes of access, again, commercial, non-commercial research. The rights of ILCs to determine access to genetic resources where they have established rights to grant access need to be at least recognized in national ABS measures. Then we have compliance with international access standards. These are the Nagoya Protocol under Article 6, paragraph 3 includes a whole list of so-called international access standards. And here you see a list like legal certainty, clarity, and transparency of domestic ABS legislation or regulatory requirements is required. It is also required that states in their access legislation or in their access measures provide sufficient and clear information on how to apply for prior informed consent. Clear and transparent written decisions by competent national authorities shall be issued in cost-effective manners within a reasonable period of time. So there is a whole lot of access standards which you can find in Article 6, paragraph 3, which the national or the domestic access measures should comply with. Then the next point which should be regulated with regard to the access issue is the access determination process. There are different steps that could be foreseen in ABS measures with regard to the access process, such as starting off with an application to a competent authority. So we need to provide specific information, what needs to be provided by an applicant. So in our situation, what information does Pharmaco need to provide to the government or the National Biodiversity Authority in Mogli in order to apply for access? The next step would be, of course, from the provider side, a review of the access application. This should be a transparent and non-arbitrary review process. So the user who applied for access should have the opportunity to also understand how the review process is going. The conditions of reaching mutually agreed terms. There must be clarity with whom the applicant must negotiate. For example, in our case, would it be sufficient to negotiate only with the indigenous and local communities if they have a co-ownership, or do they have to negotiate with both, and what are the conditions, etc. The access determination, which would include a specification against which criteria an application or access is granted or is refused, and the determination should come in a written form, indicating also the conditions for denial or for providing or granting access. And last but not least, another access or step in the access procedure would be an appeal, a potential appeal. So if an access application is denied, there should be the possibility to appeal such a decision and clarify the administrative procedures. Special considerations should be given to three, according to Article 8 of the Nagoya Protocol, to three particular issues. One is non-commercial research. If you read the Nagoya Protocol, it says that simplified procedures should be foreseen for non-commercial research. So this needs to be reflected in the ABS, domestic ABS regimes again. Then special considerations also in emergency situations. This refers to pandemic or cases of pandemics, where access should be again granted under facilitated conditions. And then, last but not least, generic resources for food and agriculture. Coming to the next element is, of course, the benefit sharing aspect. Again, the measures can clarify